Hello and welcome back to the channel for another update in the Vallow Daybell case. Today's update is a little bit of a side update. We're going to talk about the custody battle between Melani Pawlowski and Brandon Boudreaux. Remember that Melani Pawlowski is Lori Vallow's niece and is interwoven into the whole saga. So this is an important hearing to pay attention to because their trial is upcoming in November and there are going to be a lot of witnesses and information brought forth in this custody trial that could have some bearing on the Vallow Daybell case. So let's get into it. The main thing that happened in this hearing that was held on October 8th was that the judge appointed a behavioral health professional to conduct a comprehensive family evaluation. So let's go through the documents real quick and we'll talk about what it means and what we can expect to see coming up in the near future. Page number 1. It is ordered appointing the following behavioral health professional to conduct a comprehensive evaluation in this case. Carol Mellon will be providing this assessment for the court. Number 1. The scope. Comprehensive family evaluations typically involve 20-plus hours of professional services. CFEs investigate long-standing and broadly based issues of family functioning and parenting capacity. Parents and children are interviewed more than once. Psychological testing is often administered. Parent-child relationships are examined in greater detail than in a limited family assessment. Documents submitted by attorneys are accepted for review, usually without screening by the evaluator. More collateral witnesses are typically contacted than in an FA and may be interviewed in the office. The report will likely be lengthier than in an FA and provide a narrative of the family's historical context, parent-child dynamics, assessment of parenting capacity, assessment of the child's developmental needs, and a full range of recommendations addressing legal decision-making, a detailed parenting timeline schedule, and recommended therapeutic interventions, sometimes including treatment goals. The issues to be addressed are the fitness of both parents, legal decision-making recommendations. Number 2. Timely written report. The evaluator shall prepare a written report that is due on 11/9/2020. The report shall be delivered to the court and counsel or the parties if self-represented, unless the evaluator asserts extraordinary circumstances, such as imminent life threat or the potential for serious harm to a person related to the case. In that event, the court shall make a ruling regarding the dissemination of the report. The acceptance of this appointment by the evaluator indicates a capability of completing a written report in a timely manner and the ability to appear and testify in court upon reasonable notice. Number 3. Initial contact. Counsel for both parties or the parties if self-represented shall make the initial contact with the evaluator through a joint conference or conference call within 10 days of the receipt of this order. The initial conference with the evaluator shall be used to summarize the issues present in the case, to arrange for the initial appointments of the persons the evaluator wishes to examine, and to allow the evaluator to request information he or she believes to be pertinent. Number 4. Authority of evaluator cooperation by parties and waiver of confidentiality. The evaluator shall have the following authority with regard to the minor children and family members. A. The evaluator shall serve as an expert for the court in order to provide data and opinions relevant to take care of legal decision-making for and parenting time with the minor child, in this case, pursuant to the applicable Arizona statutes and case law. B. The evaluator shall have reasonable access to the children, family members within reasonable notice, and shall have reasonable notice of any and all judicial proceedings, including requests for any examination affecting the children, and shall be provided copies of all minute entries, orders, and pleadings filed in the case. C. The evaluator shall also have access to all therapists of the children and parties, all school and medical records of the children and parties, any and all psychological testing or evaluations performed by the children or the parties, any and all teachers, child care providers for the children. D. At the request of the evaluator, each party shall execute any and all releases or consents necessary to authorize the evaluator's access to the information described herein. No new clinicians, i.e. therapists, psychologists, and social workers, are to work on this case during the course of the evaluation, without the consent or authorization of the evaluator, unless otherwise authorized by the court order. The services of existing mental health providers may be suspended by the evaluator pending review by the court. E. The parties are informed that the court is identified client of the evaluator in this case. The evaluator serves the court in this case. Therefore, neither the parties nor their children are patients of the evaluator. There is no confidentiality relating to the parties' communications with or to the evaluator or concerning the evaluator's activities or recommendations. The evaluator may engage in written or verbal communication with any person he or she perceives capable of providing information relevant to the care and welfare of the child. F. The evaluator may request that the parties and/or children participate in adjunct services to be provided by third parties, including but not limited to physical or psychological examinations, assessment, psychotherapy, co-parenting work, or alcohol and drug monitoring and testing. The court shall allocate between the parties the cost of any adjunct service. G. The evaluator shall be promptly provided all reports, records, and documents requested and shall receive the cooperation of all parties and counsel involved to ensure that the report is submitted by the date requested. This order shall act as a release by the parties of all information requested by the evaluator and shall further obligate parties for any costs associated with the production of those records to the evaluator. Any such costs shall be paid promptly. 5. No ex parte contact. Counsel shall not have any substantive ex parte discussions with the evaluator, but shall conduct all communication through conference calls or conferences unless agreed upon otherwise by all counsel. Copies of any documentation provided by counsel or the parties and the evaluator shall concurrently be sent by the providing person to either side. Copies shall be sent to counsel if the other side is represented by counsel. The evaluator may have ex parte contact with the court regarding scheduling matters. This does not prohibit the evaluator from having individual contact with each party in the performance of the evaluation. Number 6. 6 is all about the fees. That's great. Number 7, evidence. The written report of the evaluator may be received in evidence without the necessity of any foundation and without any objection to hearsay statements contained therein or any other objection. Number 8, testimony. Each party shall have the right to call the evaluator as a witness. If only one party believes that the evaluator's live testimony is necessary in addition to the written report, that party shall initially be responsible for 100% of the costs incurred in connection with the evaluator testifying at the court hearing, subject to reallocation by the court if appropriate. And number 9, immunity. Services provided under this appointment order will have quasi-judicial immunity to the extent that it is afforded under the law. So, basically, this evaluator has a lot of protections, a lot of authority, and can really do a lot of digging. Now, it has seemed from what we heard from the hearing that both sides, that Brandon and Melani, both agreed to have this evaluation done. So let's hope that they both follow through with that and this is able to be done on time. Now, there is a time limit that has to be done by November 9th. That's kind of short term for all of the stuff that has to happen here, but we'll see how it goes. Now, a couple of other things that happened during the hearing that aren't part of this document. One of the things that was brought up was who's going to be allowed in the courtroom. The judge is talking about the upcoming trial, and they want to have it in person because there are 2 days scheduled for the trial. So a Zoom meeting type thing is not really the most, efficient way to get that done. So who's going to be allowed in the courtroom? Now, one of the attorneys was asking about that, and he didn't particularly say media directly, I don't think, but the judge addressed that and said, in regards to the media, if they did make a timely request to have video in the courtroom, he could not rule against it or would not rule against it. So there's a possibility. So hopefully Justin Lum heard that, Nate Eaton, somebody will be there and we can get some video of this trial because it's going to be pretty interesting. Remember, Melanie Gibb is supposed to testify on behalf of Brandon Boudreaux, which I find very curious because let's not forget, Melanie Gibb was involved with Melani Pawlowski when they were trying to track down where the children were. Melanie was the one driving around helping to locate these kids on Melanie's behalf. Melanie and Melanie. Yeah, they were in cahoots. So the fact that now she's going to flip and testify for Brandon, very curious. It was also mentioned, or at least it's still part of the ongoing process of this case, that there is still an open investigation into the shooting attempt on Brandon Boudreaux, and Melani Pawlowski is still a person of interest in that case. That's kind of a big deal. So all I can say is I'll keep you updated with anything else that comes up with this. The next thing which we should hear from them is on November 9th. So I don't know if that's going to be televised. Probably not. That's not the trial. That's just the next motion hearing. But if the trial is televised, of course, we'll bring it to you live, and it should be very interesting. So, the documents are up in Discord if you want to get a copy of them. You can also find them on Justin Lum. Follow him on Twitter, JLumFox10 at Twitter, and you can follow him on Facebook. Links are in the description. But before we go, one more thing. If you hadn't had a chance to check out this new channel that was just launched recently by my very good friend Jess Nelson, I really hope you'll take a minute. You see the thumbnail on the screen. Her latest video is amazing, really thought-provoking, wonderful stuff over there. Links in the description. iCard is up above. Please go give Jess a watch, a like, and a subscribe. And I hope you'll find her just as amazing as I do. So until then, I will talk to you all soon. Stay safe out there, and bye for now.